My lord, with all respect, my lord. Yes. Should I mention or not, my lord? One appeal, my lord. Lordship had at some point of time in 21, my lord. Thereafter, it came many number of times. In 21, my lord, with all respect, my lord, it was hearing, my lord. We sought for bail, my lord. Lordship said it's a case, my lord, where it should be heard at length, my lord. But it has not been listed many number of times in between. Sometimes we took time, prosecution took time. Can it be taken up tomorrow, my lord? If possible, my lord.
Tomorrow not possible.
No, my lord.
Next week, see the bench and then you.
My lord.
Is it a parted matter?
No, not at all, my lord.
Tomorrow not possible, Mr.
My lord, my lord.
We already have some matters.
My lord, my lord.
Next week you make an attempt.
My lord, my lord, my lord.
May I plead your lordship? Your lordship, item number 4 daily list. I beg to mention your lordship to adjourn the matter for the day and list the matter after 2 weeks, lordship. I was taken the concern of the other party.
Why it has been listed? Pass an order. You be there. You be there when the matter is called up. Then we'll consider it. Yes.
May I plead your lordship? Lordship, I criminal appeal bail matter. Convicted appellant is convicted in jail.
Appellant is
Convicted in jail. Jail hoy.
Achha. Okay.
Mental listed maybe tomorrow.
Tomorrow, no listing for tomorrow and day after. Next week.
Lordship.
Next week. Yes.
Okay.
Yes.
Item 1.
This is a reference preferred by the state of Assam, your lordship. I've checked the office note, service is complete, but because of the ongoing process in the translation wing, the paper book could not be prepared. Office note says.
The Kumar is appearing as amicus.
Yes.
So if the service is complete and the accused has not engaged any counsel, my lord, then I think amicus curiae should be record to all of people.
All right.
No?
Mr. Z. Kamar, learned senior counsel, is present as senior counsel who has been engaged as amicus curiae in this death sentence reference, is present. Ms. B. Bhuya, learned APP Assam, appearing for the state, submits that service is complete in this case. Also, however, it appears that the paper book is not yet ready. Be that as it may, register to expedite the preparation of paper book. And also verify whether any counsel has entered appearance on behalf of the accused. First of if not, let a legal aid counsel from the panel prepared by this High Court be engaged so as to represent the accused. List this case again with appropriate office note after 4 weeks. After 4 weeks.
Item 2. May I please, your lordship?
Yes.
This is a jail appeal, my lord. Paper book receipt, my lord. This is jail appeal, my lord. Paper book receipt.
So we'll have it for hearing. What is this matter? Private respondent, sir?
Oh, I don't think so. This is a matter under 376, your lordship.
376. Victim or informant has been served. It is now mandatory to serve the victim, is it not?
Especially POXO matter. Report matter, sir. Report matter. Yes.
Mr. A. Azad, learned amicus curiae, is present on behalf of the appellant. Ms. B. Bhuya, learned APP Assam, appearing for the state, is also present. This appeal against conviction has been admitted by order dated 28/7/2022, and the paper book is also ready. However, from the office note, it is not clear as to whether the informant stroke victim to whether notice has been issued to the informant public victim in this case. It's the registry to therefore verify and take appropriate steps for issuance of notice to be served upon the informant public victim, if not already done. Let the matter be listed accordingly.
Informant is not a victim, stepmother of the victim, informant.
Informant. Then victim is not required, informant. Who is to be served? Informant. or-
Victim. Lordship, I have got the judgment.
Yes.
There are 8 and 9.
Since the conviction in this case is under section 376 IPC, read with POXO,
Dreaded box.
read with
Yes.
section
4 of POXO.
section 4 of POXO, in terms of the judgment
67. Yeah.
passed by the division bench in the case of Deepak Nayak versus State of Assam, third bracket criminal appeal J bracket close 40/2022. Notice would have to be served upon the victim. Registry to therefore take steps for issuance of notice upon the victim to be served through her natural guardian. Let the matter be listed accordingly with appropriate office note.
Lordship, instead of 4, it would be 6. Conviction was 6.
Section
That's
6.
So we have to for fixing the matter after 2 weeks or 3 weeks because he is in custody since 2019.
It's the matter after 4 weeks along with appropriate office note.
Item 3.
Amicus has not been appointed, it seems. Is it?
Lordship, but one, R. Sharma's name is shown in the cause list. This one.
What about notice to informant? I think these appeals were admitted before the division bench judgment. So notice has to go to the informant. The learned amicus curiae is absent, although his name is shown in the cause list. Ms. B. Bhuya, learned APP Assam is present on behalf of the state. This appeal has already been admitted. However, after the judgment of the division bench passed in the case of so-and-so versus so-and-so, notice would now have to be served upon the informant. The registry to therefore issue notice upon the informant, making the same returnable in 4 weeks, that the matter be listed accordingly. That is the This is only in POXO case or in all cases?
376 also, Lordship will kindly have a look at. Where
But,
I,
this is 302.
I don't have a, I'm without the brief. Then 302 it may not be required, Your Lordship.
So Bormoti Pangeng still remains.
Yes.
Only clarification is that in POXO matters. Then last line you delete it. After the judgment also. Let this appeal be listed for hearing in due course.
Item 4.
May I plead your lordship? Your lordship, I'm appearing on behalf of Arch State Learned Council. Your lordship, I humbly request before you to list the matter after 2 weeks, your lordship. Taken out the consent of the other party also. Lordship.
What do you say?
Lordship, on the
The
last
applicant's
occasion, they have
counsel has
taken
sought
time.
Adjournment in this case with a prayer to post the matter after 2 weeks on the ground that the arguing counsel, Mr. R. Chetri, is out of station. is B. Bhuya Learned APP Assam and Mr. You are appearing in this case, Mr.
Not.
B. Bhuya Learned APP Assam is present and does not have any objection if the prayer is allowed. Registry to therefore, list this matter again after 2 weeks.
Much obliged, Lordship.
Item 5.
Here we have filed our objection, my lord, yesterday. License copy?
This Boxer matter probably service is not completed. I could not check that order.
Oh,
Victim
here's the
victim
service.
has to be served.
Lord.
And who's the informant here?
Informant is another person, also not related to the victim. Oh, sorry. Informant is Lordship.
Informant is another.
Mother
LCR has been received. LCR has also not been received. But Mr. Mohammed B. Islam, Learned Counsel for the applicant, Ms. B. Bhuya Learned APP Assam is present on behalf of the state and prays for 2 weeks further time to file objection. It appears that the LCR has also not yet been received. In view of the above, office to issue reminder for the LCR, let this matter be listed again after 3 weeks, along with the objection, if any filed by the state.
Item 7.
We have already entered our appearance, madam, but in the last order, maybe mentioned that some service is responsible but two for informant.
Yeah, for the informant.
We have already entered our. And there is an order of 38, my lord, there is some defect in the IA, they have mentioned order is 38, my lord. So they had prayed for a rectification of the IA. For certain sectors, but we have not received any rectified copy.
No, rectification is only to the extent that in the cost title, instead of 389, it was written 374. The section of appeal was written in that IA, my lord. That was duly rectified. In the registry, my lord, we took leave of this court to get it rectified, my lord, it has been rectified. We took.
So your status file objection.
I don't.
Yes, they filed objection.
Yes, it is there. You have a copy of your objection.
I'll get it from him if they do the matter today.
Applicant to serve a copy of objection of the state to the Learned APP. Is that?
No, Shamima has, Jahan has filed. If he does it today, then I can do it. কেতিয়া কৰিবা?
Next.
এইটো দিনে copy টো দিয়া নাই।
My lord, then let it come in any other date, my lord.
Yes, well, in the meeting, we will file our application.
What objection you will file? PP is there, status file. Your presence is only to assist the PP, not beyond that. When do you want it, Mr. Biswas?
My lord,
Mr. M. Biswas, very counsel for the applicant. So heard Ms. B. Bhuya Learned APP Assam appearing for the state. Mr. M.J. Kadri, Learned Counsel has entered appearance on behalf of the respondent number 2 stroke informant. Informant or victim?
Informant.
Informant. As such, this matter is ready with regards service. On the request of Learned Counsel for all the parties, registry is directed to list this matter again for orders as a fixed item on 22nd of November, 22nd.
22nd of November. Was like.
Item 8.
Make clear, your lordship. Dear lordship, this IA has come up for consideration of bail of applicant lordship. Here two appellants are there, mother and son. And allegation was that their daughter-in-law of the appellant number 1 was murdered by these two persons, lordship, in the morning, and she was administered poison forcefully, lordship. This is the allegation in the FIR, Lordship. And what I find, Lordship, subject to correction, what my learned friend says, the entire conviction is based on circumstantial evidence. And the only circumstance which I find is that they initially said that Harpic, the victim consumed Harpic because in the her body was found in the bathroom. Harpic was lying there, and foam like blue color foam like was coming out from her mouth. So they suspected that she consumed Harpic. So from initial stage, they said she consumed Harpic. Even the first information report was lodged by the husband, the present applicant himself. And the learned trial court, Lordship, after getting the FSL report, it was there that she consumed organophosphoric. And therefore, there was discrepancy because of that they were convicted because it was held that they took a false plea. But if your Lordship see the evidence of PW7,
Seven means there's only one applicant here.
applicant one, but there are two applicants, mother and son. Mother was already granted bail by this honorable court. Because two applicants were there, her health condition was not good. Therefore, son said that first you apply for mother, then my case may be placed. That I have enclosed her bail or
What is test the water first
lodge.
to the mother,
Lodge.
is it not?
That in the IA Lordship, page 15 is the order.
Yes.
Although it was heard at length, Lordship, but only on this ground, she was granted bail.
Yes, so what is your submission? please?
My submission is that, Lordship, the brother of the informant who lodged the case on 11/11/2014,
Brother of the informant.
brother of the victim, Lordship, the deceased, brother of the deceased lodged the affair on 11/11/2014. Whereas on the date of incident, that is on 10/11/2014, after the incident, husband immediately took the victim to hospital and also informed the police, Lordship. Immediately after the occurrence, there was not, it was not like that they were,
So according to you, how did the victim die?
she consumed some poison, Lordship. That what was that at present it is difficult to say, Lordship, because when they arrived at the place of occurrence, they found Harpic was lying there. Blue foam was coming out from her mouth, Lordship. So they suspected that Harpic was she consumed Harpic. Even if your Lordship see the evidence of PW7, who was the immediate neighbor, your Lordship will find that when they found the victim in the bathroom, this appellants, they raised hue and cry. Immediately, all the neighbors went there. And they also deposed in a similar manner, which I have submitted before your Lordship. PW7, Lordship, may kindly see for a moment.
Let's see the LCR. Paper book is there.
PW7, page 31, Lordship.
1 minute. Where is the medical report?
Medical report, your lordship will find.
FSL report is there.
Official report is there.
105.
One.
So any signs of strangulation in the
No.
body?
No. Only that organophosphoric. lordship.
No, I wanted to see we wanted to see the PM report.
PM,
post-mortem.
PM report, lordship, page 93.
Obviously, it's a poison. That's how she died.
Yes.
Yes, they are
That's-
pleased that she can consume Harpic, my lord. But your lordship,
That's not the point.
yes,
If you forcefully feed poison to a person, there has to be some signs of some kind of physical force.
yes.
Otherwise, it has
Lordship,
to be-
but when the occurrence had taken place,
Mm.
the deceased had died, members of the husband's family did not inform the parents, your lordship. It was a neighbor have informed, and they have secretly tried to, your lordship, this one, my lord, to what do I say, my lord?
Cremated.
Cremate the dead body, my lord. Then the victim's family arrived and they stopped themselves, your lordship. And there were, as per the evidence of the PW4, your lordship, there was they have assaulted a victim, your lordship. They have beaten the victim in the morning, and then when the victim tried to come to a parental house, the two
Let's see the
accused
medical report. Postmortem.
Page
postmortem.
93, lordship.
The heart congested and contains blood in the chambers. Vessels contains blood in the chamber.
No, the only question I'm asking you is, how do you forcefully make someone consume poison without signs of any physical force in the body? How can you do that? Is it possible? Will anybody
It may be.
voluntarily consume poison?
Lordship, might have been mixed somewhere with the food. Then then there will not be any injury on the body of the victim.
But is that the case of the prosecution?
It's a lordship, but the conduct of the person's lordship, subsequent conduct, and whatever allegation given by the victim before before commission, whatever has happened, your lordship, that
See
the
the IPC. Conviction is under which section?
302,
302
34.
302?
and PW4, my lord, PW4 is a neighbor, my lord.
So any allegation of dowry demand or torture, etc.?
Yes, lordship.
there
If your
evidence?
lordship looks into the evidence of PW4,
Yes.
PW4 is a neighbor.
Mr. Ahmed, you have the hurdle of 304B. It was 2.5 years within the marriage.
That is there, but if your lordship
There is
see
a
the,
presumption against you.
but if your lordship see the evidence of PW2 brother, there was no allegation of
Yes, so that leaves us only with one option.
Okay.
Tell us the date for final hearing, nothing else. How do you dislodge if there are allegations of dowry demand and torture?
Lordship,
If there is prima facie material to indicate that,
lordship.
then the 304B presumption steps in and you have to, it kicks
No.
in.
Although my
You have to
learned friend,
dislodge it.
Lordship, although my learned friend said there is the allegation of dowry demand, but if your Lordship see the evidence of PW2, he was confronted with that, although he stated in examination in chief about demand of dowry, he has not stated before police or in the FIR. That is also confirmed through IO, Lordship. So
Lordship.
those contradictions he cannot brought in here, Lordship.
Lordship, evidence of PW3 also. After 3-4 months of marriage, the accused Ratanda started demanding 4,000 rupees, 5,000 every month. We had paid the monies initially. Later, the accused also started beating my sister for money.
302 can be brought down to 304B also with a slightly lesser punishment. Reverse may not be permissible.
No, but in this case, charges were probably framed under section 304 also, but he was not convicted.
He was
Because
acquitted.
because
Oh,
of this.
there are
discrepancy.
judgments to show that whenever there is a 304B allegation, charge has to be framed under 302 also.
Lordship,
But if the conviction is under 302, that
Lordship,
does not mean acquittal under 304B. That's done.
that I am not.
All right. Now, there could be a case where through circumstantial evidence,
Lordship,
the prosecution might have failed to establish a charge under 302.
Lordship,
That is possible.
Okay.
But even in that case,
Lordship,
the ingredients of 304B being present,
Lordship.
the requirement of a rebuttable presumption against the accused
Lordship.
kicks in, and that presumption has to be displaced.
So that presumption will come only if they show that she was subjected to torture in connection with demand. That
Yes.
requirement is there. But here from the evidence, Lordship, what I find, first of all, Lordship, that demand of dowry they have not stated before investigation or during or in the FIR, Lordship. That is also confirmed. And regarding that other thing, it is not there, Lordship, that in connection with demand she was tortured.
The torture need not be in connection with dowry.
That it has
You
to be.
please read this
Lordship.
section 304B.
Manual conduct.
You're getting the point. Read 304B.
Mary. 304B, dowry death, where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage. And it is shown that soon before her death, she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for
There
dowry.
is a or before this.
No, Lordship, before that, husband for or in connection, for or in connection.
Lordship, evidence
So
of
that
PW3 is a
torture has to be in connection with demand of dowry.
Mm.
So mere torture, that will not amount to Lordship 304B.
Yes.
And here, if your Lordship see the evidences, Lordship, what I find that there was no demand of, there is no torture in connection with demand of dowry. And apart from that, as reflected from the judgment, Lordship, only the explanation is that they stated about Harpic and the official.
You argue the matter, it's all as good as hearing, final hearing. We'll do it next week, next Tuesday. You argue the appeal on merits.
I leave it up to you, Lordship, but that
nothing
I.
to leave.
maybe-
The same effort. We have to go through the entire judgment. We rather hear the appeal itself.
Lordship, here is only the case is based on circumstantial evidence. That is my submission. Lordship.
Next Tuesday for
My lord.
final hearing. Not
I am
Mr.
maybe kept pending, Lordship. I am maybe kept pending, Lordship.
Learned counsel for the applicant appellant also had Ms. B. Bhuya, learned APP Assembly training for the state. This IA has been filed with a prayer
Deep ki
to
hoga tha.
suspend the jail sentence awarded to the applicant and also for his release on bail. After hearing the preliminary submissions made at the bar, we are of the opinion that the effort that would be necessary for considering the IA would be more or less the same, which will be needed for hearing the appeal finally. Since the appeal has already been admitted and the paper book is ready, as agreed to by learned counsel for both the sides, let this appeal be listed on 24th of November
24th.
2023 for final hearing as a fixed item. The IA is kept pending.
Mm-mm.
Item 9.
9 Supply. Section 5 is no? बोलिए तो उसमें bill rejected. 8 September.
Maybe lost its honor. This is the application under section 391 of the CRPC matter for reducing of additional evidence. Because the main link was missing because of the accused number 2, who was said to have picked up the girl child, and handed over to accused number 1 in his shop on that day at about 1 p.m. of 6/6/2017. My lord, he was in the hospital on that day.
Just a minute, Mr. Sharma. The appeal is ready for hearing.
It is ready.
Paper book is ready.
These applications are to be considered at the stage of hearing when the appeal is being heard. It is at that stage the court will consider.
And
And
there are two options, my lord.
yes,
One judgment of 3 judgments of 1965 says it can be heard because it is evidence to be taken that must be taken before the appeal is finally heard. And second, now latest judgment is from, I think it is 2023 in live law, my lord. The appeal should it can be heard with along with the appeal. So, lordship can fix then this along with the appeal will.
all right.
Finally
Your
hear-
prayer remains live,
Yes,
but when the appeal is heard, because the court will have to go through the matter and then.
yes, yes. Yes. Because the man is what I am, in fact, it was default in our part also, because the man, he was a tea garden laborer. He was not educated. He was suffering from this alcoholic syndrome. He was admitted in the hospital, tea garden hospital. And before it was serious matter, then he was referred on the 6th June morning, where the incident is said to be taken to Medical College, Jorhat. And in his 313 statement, he has said, I am innocent. On that day, I was in the hospital for treatment. He doesn't know the name of the disease, my lord. He was actually suffering from alcoholic syndrome. He said, I was for blood pressure, high blood pressure, I was in the Jorhat Medical College. That was not at all discussed by the trial court. My lord, 313, you also knows, even our High Court judge in Raman Saikia case, my lord. 313 has important role to play. That's why it is
But
incorporated.
in any case, if that is,
Yes,
if that has not been considered,
yes.
then the matter will in any case be remanded. So let it be.
That is what.
There is no need for any separate service in this IA.
Yes.
No.
Because once the appeal is there,
Service is already,
we take it up along with the main appeal.
Yes.
At the
If
stage-
your lordship considers that additional evidence is to be taken, then it's up to your lordship.
That's what. And in any case, if the 313 statement of the accused is not considered and it factors in during in the judgment of conviction, and if the court finds it causes prejudice, then the matter automatically is to
Lordship.
be remanded.
Even IA is also not necessary. It's up to the court.
No, but all right, for
Yes.
his satisfaction,
Yes.
I heard Mr. R.P. Sharma, and senior counsel assisted by Ms.
Edeka.
Edekal and counsel for the applicant. Also heard Ms. B. Bhuya, learned application appearing for the state. This IA has been filed by the appellant
Hmm?
in criminal
No,
appeal number
it-
92 of the 2023, seeking leave of this court under section 391 of the CRPC for additional evidence. First of all, we have perused the grounds taken in the IA. The prayer made in this IA shall be considered at the stage of final hearing of the connected appeal. Registered to therefore list this IA along with the appeal for final hearing in due course.
Right, well, they are in jail.
Oh, he's in jail.
66 years old man.
Bail was rejected.
Yes.
The IA is rejected.
Can I be-
When do you want it?
Well, By, can it be by December first week, my lord? Any Tuesday or
Cox, sir, could you?
December first to Thursday you get.
fifth of December, my lord?
Fifth.
Fifth of December, obliging.
Monday, not Tuesday,
This
Monday
is
again?
final hearing on fifth of.
Monday.
This is the
Okay.
IA.
Okay,
we appeal to final.
Item 10.
Fifth of December.
Lordship, fifth, my lord. Right,
Mhm.
yeah.
May I please let you know, this is for confirmation of 47 days delay in preparing the connected API.
Is notice required to be?
Yes.
issued? I had Mr. RKD Chaudhary and a BSJ appearing for the applicant. There is the statements made in the application. This IA has been filed under section 5 of the Limitations Act 1963. With a read with section 21 bracket 5 bracket close of the National Investigation Agency Act, 2008, with a prayer to condone the delay of 53 days in preferring the connected appeal. Issue notice calling upon the sole respondent to show cause as to why the delay should not be condoned. Steps within 3 days from today by registered post with AD for service upon the respondent. Let the matter be.
Lordship, there are two respondents.
Two respondents. Only one name is in the respondents. Yes.
Oh, my lordship.
Two respondents.
Item 11.
So 5 days of delay, we would condone it normally, but should a notice go or,
Lots may condone only 5 days delay.
all right, statutory appeal. I had Ms. P. Burman, only 5 days. Ms. P. Burman, learned counsel for the applicant. His IA has been filed with a prayer to condone the delay of 5 days in preferring the connected mat appeal, full stop. The applicant as appellant has preferred appeal against the judgment and order dated
17-8.
17/8/2023. Passed by the learned principal judge dash capital Roman 3, family court, Kamrup at Guwahati. Allowing the petition filed by the respondent, thereby granting a decree of divorce, full stop. Since it is a statutory appeal and considering the ground on which the delay is sought to be condoned, we are of the opinion that this is not a fit case where the matter should be kept pending for service of notice upon the respondent. As such, by exercising our inherent jurisdiction, read with section 5 of the Limitations Act, we condone the delay of 5 days in preferring the connected appeal, register to office to register the mat appeal and list the matter for admission after 10 days. IA stands disposed of.
Supplemental list for orders, item 15.
Inherent powers, not inherent jurisdiction.
Can I say? Okay.
May it please your lordship, my lord, as per last office note, my lord, paper book is not yet ready, my lord.
Paper book is ready.
Not yet ready, my lord.
So you write that for ends of justice, not inherent for ends of justice and having regard to the peculiar facts and circumstances. We are of the opinion that this matter should not be kept pending only for service of notice upon the opposite party. We therefore condone the delay of 5 days in preferring the appeal. Office to register the mat appeal and list for admission after 10 days. IA stands disposed.
My paper book is not yet ready, my lord, as per last.
Lordship.
But Mr. R.S. Mr. counsel for the appellants of Ms. Eve. Learned PPRs and appearing for the state. It is submitted at the bar.
Office notes, I saw.
Although the records have been received, yet the paper book is not yet ready. In view of the above, it has to expedite preparation of paper book and list the matter thereafter for appropriate order.
For hearing item 12.
Yes.
May please your lord. But in fact, the divorce was filed with the husband before the family court sale check. And it was
Bail application, my lord, under the NIA provision of NIA, my lord. So in this case, my lord, there were 7 accused persons who are facing trials, my lord, in the instant case. And out of the 2 of the accused has been released on bail, my lord. One is Amrit
Where is the order
Vallabh,
impugned? Which page?
my lord. Your lordship wants to repeat.
66.
Is it a common order for both the appellants?
No, my lord, not the common.
But same grounds?
Same.
Page 66.
So this is a separate one. Right now we are dealing with probably item 13. Item given 13, my lord. 14, there is a common order, my lord. In 14, there is a common order, my lord. We'll come later on, my lord. That stands in a different footing, my lord. There are certain high court directions on item 14, my lord.
Right.
This is an independent one, my lord. So this accused petition appellant before your lordship is one Indra Mohan Bora, who is aged about 29 years, and he is a businessman, my lord, having a small shop, a stationery shop in the Nagaon city, town, my lord. He's having a photo state and stationery items. So, my lord, I have been held up in this case, my lord. This case relates to that granite blast in the Central Mall, my lord, in the heart of the city, my lord. So, in this case, I have been held up because of the fact that I'm said that I have harbored the accused number 1 of this case, my lord. I have relation with him, my lord. That is the only allegation against me. No specific act, nothing has been attributed against me. So, I'd like to take your lordship to the charge sheet, my lord, at page 26, my lord, of the appeal memo, my lord. Contention can you put this on? Is given. This is the man, my lord. He is AA5 Indra Mohan Bora, my lord. His particulars is given at page 27. He was charged sheeted under 120B, 18, 19, 38, and 39 of the Unlawful Activities Act, my lord. But since the law of 120B and 18 is parametrics, my lord, so while framing the charge against the accused, my lord, 120B was taken out, my lord. So now we are left with 18, 19, 38, and 39, my lord. So before going to that, my lord, I'll inform Nasan.
UAP Act. The charge has been framed under what section?
My lord, charge has been framed under 18, 19, 38, and 39, my lord. And I have prepared a list, my lord. Even Nasan. Yeah, photo written indicated. 18 UAP Act, punishment for conspiracy, my lord. Because when special act is there, my lord, special provisions are there. Or Thojax Moko. Science. One line. Excuse me. Down. At a safe photo state could you? Hey, lawn again. Reflection will have strain. Man to everybody is in.
Yes, please.
So, my lord, this it being parametric, my lord, so that 120B has been deleted, my lord. Charge has been framed under 18, 19, 38, and 39. So, I'd like to take your lordship, my lord. That 18A UAP Act is punishment for conspiracy, and the punishment is not less than 5 years, my lord, but may extend to RI for life. Then 19A, my lord, punishment for harboring not less than 3 years but may extend to RI for life. Then 38 UAPA offense relating to membership of a terrorist organization, and 38 UAPA offense relating to support given to a terrorist organization. So not exceeding 10 years in both the sections, my lord. Now, the only allegation against me is that my phone number, which they are alleging, match while making CDR analysis, my lord, with one of the accused person. That is the only allegation. Now, that allegation has been stated at page 46.
The trial is under progress.
Yes, my lord. Trial is under progress and 16 or 17, 15 witnesses has been examined. 17, my lord.
What 17? What is complete? 17.
Okay, anyway, 15 to 17 witnesses has been examined, my lord, and there are about 237 documents and 237 documents to be exhibited to them as they have claimed it under the 207 provision, my lord. And out of that, my lord, now 160 PWs
This
are
is the
yet.
first bail application by the applicant.
Yes, my lord, after filing of the charge sheet, if I'm not wrong, my lord.
The LCR copy is here.
Scan copy. Probably it was called for, it has come.
Just check. Mr. Dev Chaudhary, the scan copy is here. Are you aware?
Yes, there we have got the evidence copy there, na? Evidence.
Case diary, but would like to have a look at what is there in the records.
Till now, nothing has surfaced against me, my lord. I have got the certified copy of the depositions, my lord. Alisa Khaki ne dekhajila certified video.
The lordship permissive. My colleague says it can be made in blue.
It can be,
Scanned copy of the.
yes.
Tuma certified copy in Louis College.
2 days, lordship.
But sorry,
In 2 days, lordship, it can be made.
Na, I'm with you. Ekon purana final.
so Mr. Kamar,
My lord.
is one thing. Now, since the trial has commenced,
My lord.
at least the court would have to have a look at,
Absolutely,
This
my
can
lord. That's
copy.
very correct, my lord.
is it, it's not there. Then,
The scan copy was called for, I think. Hey, nah, yeah, to me, lose. My lord, these are the evidence, my lord. Which certified copy of the evidence. So, lordship would like to have a look, my lord. Not a whisper against me, my lord, till now on examination, my lord.
you have the copy, have you given? this
My
copy?
lord, we have just taken it, my lord. Certified copy of the evidence. They know it, my lord. He conducts the trial, my lord.
No, what is the stand? If you concede, then we'll pass an order. Otherwise, you will have to give, somebody has to get the scan copy.
Lordship will get the scan copy.
We'll have it on Wednesday then,
Let it be on Thursday.
Thursday.
Well, I'll just check it, my lord. One thirty.
22 तारीख 23 तारीख को
आज की मन तारीख कुछ गुजर नहीं आज की मन तारीख
it was November.
आज ही 15 day Thursday will be Friday will be
Wait, the scan copy has not been called for.
No.
we made a prayer
23 is तारीख
next week now
आज तो pregnancy हो गई
at Wednesday date
The other matter, let's see. Mr. Kamar, there is
But-
no order calling for the scan copy of LCR.
we prayed for it man Haji Babu Haji a week to us Friday
No order.
Malam
So that leaves us with no option.
Malam your lordship
When,
Malam next week he is saying Malam
If it can be on Thursday, lordship.
Thursday date to one.
Thursday it's 23rd. 23rd.
Heard Mr. Z. Kamal and Senior Counsel estate by Sonsu. Learned Counsel appearing for the appellants in both these appeals. Also heard Mr. R.K. Chaudhary, learned DS appearing for the Union of India. Mr. D.K. Das, learned Senior Counsel estate by Mr. L. Satyanarayana appearing for the NIA authorities. Both these appeals arise out of orders passed by the Learned Trial Court rejecting the prayer for bail. It has been brought to the notice of this court that the trial is under progress and as many as 15 to 17 witnesses have already been examined before the Learned Trial Court. If that is so, the prayer for bail cannot be considered by the court without perusal of the LCR. Full stop. As such, register to call for scanned copy of LCR in connection with what is the case?
With my special case number,
Special case number.
I'll give the number, no part, yeah, we have a weekend. 290, my lord.
Give the number. As on the request of Learned Counsel for.
2/119, my lord. We'll give the number.
Please give the number. Only one case number.
One case was arising out of the same case, my lord.
Common order will be.
Same similar
Request of
order will
Learned
be there.
Counsel for both the sides. Let this matter be listed again on 24/11/2023 as fixed items.
Much.
Part two. কোনো হিয়ারিং ওর লিস্টে নাই তোমারও আমি না এটা আমার একটু কেটে হল হিয়ারিং তো ওরা থাকে ওরা যে হয় নাকি কি লিস্ট কোন আছে তো 10-15টা ম্যাটার ডিপ্লে লিস্ট This is not correct. Part 2 list होता है ना था क्या जानू original list hearing होता है
Number file करते हैं তোমাকে নিলে উলাই যাব মুখ কি কপি দিয়া এটা এখন নাই তো আমার অবস্থা
वो राजू जी ना
তুমি রাজমানা পা দিদি আছে একটু মাথা তো একটু চেঞ্জ করে কেন লগাই নি তুমি যে
but anything to know about some matters has to be listed like this no এগুলো হিয়ারিং এ দুটা কেস দিলে কি হইলো তো
একটু তোমার লগতে তৈরি
দেখো
দাদু
না
কিনে
LCR
তৈরি
না মুখ না
দাদু কিনি এক দিক মাছ